So right now I'm going to introduce somebody that I haven't personally known for a very long time. He's somebody who is in the legal community a legend in the United States of America. There are few lawyers who reach the pantheon of lawyers who've argued at the Supreme Court and who are widely known and respected by their peers at the national level, at that level of constitutional litigation. It is rarefied air. I've been there, I've stood inside the Supreme Court. Just being there is sort of an incredible experience to see what goes on and to know that that's the highest court in the land. Maybe a little too high at this point, would you say? And so to sit with a lawyer like this and to hear his experience has been an incredible learning experience for me. And Chuck Cooper has that lifetime of experience. Chuck clerked for Chief Justice Rehnquist. He worked in the Justice Department in the Reagan era. Incredible experience. Obviously, Mark Levin was there, Hugh Hewitt was there, and many others that are among the greatest heroes of the conservative movement today. I think one of the most important things that he's done in his career that is so important is that he's fought for something that all of us hold near and dear, which is the preservation of and an attempt to expand back to its original meaning, the Second Amendment. That's important to us, right? Yeah. Without a strong and robust Second Amendment, everything else is at risk. The entire Bill of Rights, frankly, the whole country. The founders knew that this was the foundation for a free society, right? Men disarmed are men enslaved. And Chuck has dedicated his entire career, his life, to protecting and expanding our rights under the Second Amendment. Not expanding them and making sure we get those that were given to us, endowed by our Creator. It's not been an easy fight for most of the career. You guys probably know things have gone better in the last few years under Heller and other interpretations issued by the Supreme Court. And so it's incredible to be with a guy that was at the center of all this. I told you that it's important that you get to know people who work with us as people, not just as public figures. We can watch them on TV, we can read what they write, and we get the public figure side of things. I first met Chuck in a meeting. We'll discuss this meeting a while from now. I met Chuck in a meeting at the Jefferson Hotel in Washington, D.C. in a paneled conference room filled with luminaries that made me feel like a little leaguer among MVPs. And Chuck was there. And I think one of the most amazing things to see is how everybody else related to him. Because my impression was on this very first meeting that he had the respect of all these other luminaries, people who were his peers, yet looked up to him in a certain way. He had a gravitas of few lawyers that I've seen. I've also seen another side of him, which is really impressive for attorneys especially, and I say this as an attorney, is there is an arrogance that permeates the profession. You might have noticed. He's not one of them. The man carries himself with grace and humility that is befitting to this organization and the way we do business, and it is an honor and a privilege to introduce my friend, a supporter of Convention of States, Chuck Cooper.
Well, Mark, thank you very, very much for those kind words, and thank you for that warm welcome. It sounds to me like I'm among friends. But this is my first time being with this group. It's a great privilege and honor. But I want to get a little bit better acquainted. These days, you don't always know what you can say and what you can't say, in any crowd. But Mark, with your permission and with yours, I'd like to ask you a couple of personal questions. So first, are there any freedom-loving, anti-communist patriots in this room? Well, this takes me back to my Reagan years. Wow, this is okay. We're off to a good start here. Do any of you cling to your Bibles and your guns? Okay, all right. Okay. And tradition, yes, indeed. Well, okay, I am with friends. I may speak freely. And I want to speak about the real threat to the Second Amendment, because it's certainly not a convention of the states. And we're here to talk about convention of the states. That's our purpose, our common purpose here. That it is what we are comrades in arms about. I'm sure we are about many other things as well, but that's our common purpose here today. So I want to talk about that one singular method of the methods, that one singular method that the framers gave us to amend our Constitution, to make that document fit at age 40, even though, it fit just fine at age 14, as we heard from Mr. Jefferson earlier today. So it's one of the three methods for amending our Constitution. Right? So I see some people kind of scratching their heads. Oh my God, Chuck Cooper, geez, he doesn't know Article 5. Actually, there are two methods in Article 5, but there's another one. I want to direct your attention to Article 3. Let me read it to you. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior. That's the other method that the framers, it turns out, unintentionally created to amend our Constitution. It's not a legitimate method, but it's a method that is used very nearly every term of the Supreme Court. And it's really that method that is the real threat to the Second Amendment. Now, as I elaborate on that point, I would ask you to indulge me to take a stroll down my memory lane with me, to give some texture, I think, to my beliefs on this point. Back in the 1980s, as Mark has mentioned, I spent the 80s, both terms of the Reagan years, serving President Reagan in the Department of Justice, the second term under Ed Meese, and what is called the Office of Legal Counsel, which is the principal office within the Justice Department giving constitutional advice to the President and to the entire executive branch. And during that period, it was a time of great, conservative, philosophical ferment, particularly in the legal profession and constitutional movement. We were filled, I was a young man then, and we were filled with all kinds of energy and all kinds of hopes, many of which were fulfilled. But it was also a time when there was a lot of scholarly efforts in the 80s and then in the 90s over what the Second Amendment means, what it means, and because of, our right to keep and bear arms was then, as it has been ever since, under a great deal of stress, under a lot of challenge from the left. And when I left the Reagan administration, went into private practice, I joined an then existing group of Second Amendment scholars, academics, as well as practitioners, because my very first client when I left the government was the NRA. And as a private lawyer, advocating cases, constitutional cases, not just Second Amendment, but a variety of cases on behalf of the National Rifle Association. I became part of this group. And we were trying to develop a strategy, a intellectual and litigation strategy, to ensure that when the Supreme Court took up the issue of what does the Second Amendment mean, believe it or not, it had not done so, at least not in a fundamental sense, during the 200 years that had preceded. And we wanted to make sure that the Supreme Court ruled that it protects an individual right of all of us to keep and bear arms for armed self-defense. At the time, our litigation strategy was very easy. We've got to keep this issue away from the courts. And while we are doing that as intelligently and as energetically as we can, we have to develop the scholarly foundations to assist in the effort to persuade the Supreme Court to interpret that amendment according to its original public meaning. And that scholarship really got underway by some of the giants in constitutional law generally, but certainly in the Second Amendment. Nelson Lund, Stephen Holbrook, Bob Cottrell, the list goes on, Koppel. They were, Don Cates wrote the original, one of the original pieces on this in Michigan Law Review. It's just a real strong, organized effort, organized under the auspices and the sponsorship of the National Rifle Association, God bless it. And then suddenly, in 1999, a case was decided in a Texas federal district court called Emerson. A federal district court judge in that Texas courtroom ruled that the provision of federal law criminalizing the possession of a gun if you're under a domestic restraining order is unconstitutional. It's invalid under the Second Amendment. Well, that was a really very surprising, welcome ruling by this court, because the court held that it is an individual right that protects every citizen. But it was also an alarming one, because now the game was on. It was very clear that the United States, which was defending the constitutionality of a federal statute, was going to appeal that ruling to the Fifth Circuit Court of Appeals. And so everybody on both sides who cared about this issue formed their teams, and the NRA and I and Nelson Lund and others, under Wayne LaPierre's extraordinary leadership, formed the amicus contingents, if you will, to try to influence correctly this decision. We tried to, and we thought, well, okay, how can we be most effective? And one of the ways we thought we might be able is if we could get a state to come in as an amicus, maybe more than one state, but if we could just get one state. And so I approached an old friend, Bill Pryor, the Attorney General of Alabama, now one of the finest federal judges in the country on the 11th Circuit. And he said, okay, we'll put in an amicus brief. And Nelson Lund, Professor Nelson Lund, and I, and my colleagues put together a very extensive historical understanding discussion, bringing forward all the evidence, the real meaning of the Second Amendment. Then we decided, well, we're worried because there's a public defender who's going to be arguing this case. A public defender for this man who had been prosecuted. Is there any chance that the court might let someone else argue as well? So we took a chance and filed a motion asking if I could argue on behalf of the state of Alabama in this case. And to our great surprise, they allowed me to do it. So I argued that case alongside the public defender. And a few months later, the Fifth Circuit came out 2-1 in favor of an individual right to keep and bear arms. It was a seismic moment. This was in 2001, fully 7 years before Heller came down, 2001. So it was a tremendous moment. The opinion is unbelievable, 70-something pages of dense historical discussion about the meaning of the Second Amendment as it was intended by the framers and the ratifiers. Well, then we started holding our breath because we were worried the Supreme Court was going to take the case. And the votes pretty clearly weren't there. But the Supreme Court didn't take the case. So we had dodged a bullet, and we actually came out with a strong, strong ruling. So it worked out very, very well. A couple of years later, we heard through circles, these circles are small, that a couple of very young lawyers were preparing a challenge to the District of Columbia's effective ban on firearms. It has a sweeping ban, and they were preparing a constitutional Second Amendment challenge to that. Well, that alarmed us in this group. It would be a challenge that was well funded. It would be a challenge that was well considered. It was under the sponsorship of a libertarian organization called the Cato Institute in Washington. And, but it was just not coming at the right time in our view. So this group got together and decided, well, we're going to send a couple of ambassadors to speak to them and try to discuss whether this is the right moment, this is a wise course at this time. And so, once again, Nelson Lund and I teamed up and became those ambassadors. We approached those lawyers and we said, gentlemen, let's count up here. You're going to go in with 4 votes against you. John Paul Stevens, Ruth Bader Ginsburg, Justice Breyer, Stephen Breyer, and Justice Souter. Those are certain votes against you. You're going to go in there with 3 votes in our favor. Rehnquist, a man who I had clerked for, Justice Scalia, of course, and Justice Clarence Thomas. That leaves Kennedy and O'Connor. Now, I might at that time be willing to take the risk on Kennedy, but I was not willing, and none of us were willing to take the risk on O'Connor. And we had particularly a persuasive, I think, credible advocate with me because Lund had clerked for O'Connor. So he knew something about what he was talking about. But they decided to file the case anyway, and then once again the game was on. And since the train was leaving, we all jumped on it. And the case, sure enough, did get to the Supreme Court in 2007. But something momentous had happened in 2006. John O'Connor got sick. Tragic situation, and Justice Sandra Day O'Connor, bless her heart, left the court to tend to her husband. And a fellow named Sam Alito was nominated and confirmed to take his place. Now, Sam Alito was the first person I hired when I went to become the head of the Office of Legal Counsel. So he had been my deputy for 2 years. And I think I knew his mind. So suddenly, the guys who moved this case forward, Alan Gura in particular, he should be noted here, were geniuses, and I was the stupid guy. And I completely admitted it. And the case came out 5-4. As you know, the Heller case came out 5-4. But that's really my point here, that the case came out 5-4. 4 members of that court believed then, and there are 4 members of that court who believe today, that the Second Amendment is not an individual right, let alone a fundamental right, that applies as well against the states, which the Supreme Court held in the McDonald case shortly after Heller. They believe it is not an individual right, and therefore that Congress and the states are free to restrict your right, even to ban the private ownership of firearms. So there are 4 members of the court right now to do that. Now, just to, I guess, maybe bring the peril of the Second Amendment from this threat into contemporary, maybe sharper focus. What's happened during the decade since the Heller decision and the McDonald decision were decided? Well, The follow-on Second Amendment cases have received a very hostile reception in the federal courts, the lower federal courts. We've learned from them, for example, that from the majority of them, 2 of them have done the right thing. I'll come back to. But we've learned from the majority of those courts that the Second Amendment does not apply beyond the facts, the specific facts of the Heller case, i.e., the right to possess for self-defense within the 4 walls of your home. You cannot take it out of your home. You have no right to do that. The states can ban you from carrying a gun. A proposition that on its face is ludicrous. It's simply ludicrous. I mean, after all, it says the right to keep and bear arms shall not be infringed. Not to keep in your home, to keep and bear. And as Clarence Thomas said in a case actually in which he was urging the court to accept another case that would straighten this point out, unsuccessfully. He said, it's extremely improbable that the framers thought that the Second Amendment meant you were free to carry your gun from the bedroom to the kitchen. Yet most courts have ruled that way. 2 of them have ruled the correct way, and because of that split among the circuits, thankfully, and I have to say, notwithstanding your compliment of my humility, that both of those circuits did in cases in which we represented the party. But that division in the circuits is why now the Supreme Court has taken, and there is pending now, a case that brings that question, whether or not you have a right to bear arms outside of your home for personal self-defense, is before the Supreme Court, and we're cautiously optimistic in terms of how that case will come out. But the point is, we know one thing going into that case: there are going to be 4 votes against it. We know there are going to be 4 votes against it. We think and hope and pray there'll be 5 votes in favor of the original public meaning, which is made clear in the text of the words themselves, of the original public meaning of the Second Amendment. But it remains to be seen, and I won't, stop holding my breath until the decisions actually comes down. But we are here because the framers equipped us and placed in our hands the means to ensure that the Second Amendment means what it says. We have within our authority, the people have, to address the mistake that the framers made when they vested the Supreme Court justices with life tenure. It's that which liberated the Supreme Court members not just to be independent, a good thing, but to be completely, wholly, utterly unaccountable. Wholly unaccountable. Now, to paraphrase Hamilton, few things are less pleasing than to call attention to an occasion when the founders made a mistake. But they made a mistake with that. They couldn't have foreseen that judges would exercise will, something that Hamilton assured us they wouldn't do. They would only exercise judgment. They couldn't have foreseen that the power they placed in the Congress to address these problems. The impeachment power would be nothing more than a scarecrow, as Mr. Jefferson said. They couldn't have foreseen that those protections would be inadequate and that ours would become a government of men and not laws because of that provision. But I believe that that provision is the reason that the real threat to the Second Amendment, and not just the Second Amendment, but to every freedom we hold dear, every freedom we have. I mean, in 1868, July of 1868, when the 14th Amendment was ratified, who among them who participated in that, in fact, who in the entire country at that time would have guessed, would have thought that the meaning of the Equal Protection Clause would be that a state was disabled from defining marriage as one man and one woman? Who would have thought that? Who would have dreamed such a thing as that? Because there would not have been a single person alive in the United States of America who would have done anything other than laugh at that preposterous notion. Whether you favor that practice or whether you oppose it as a policy or a moral matter, one thing's for sure: our Constitution didn't decide it. It didn't vest 5 members of the Supreme Court to decide that. This is what we have. And it's because, I believe, of life tenure. So look at Mark Levin's proposed amendments with care, but look especially at the one that addresses the life tenure of Supreme Court justices. Thank you.
We're going to go back kind of in your history, and why don't you tell us kind of how you grew up, where you grew up, how'd you end up being a conservative, and then ultimately how'd you get into the law?
How'd I end up being a conservative? Well, you put me in mind of the famous words of Lady Gaga.
Now I got to say, that's unexpected.
I was born this way. Now, I didn't know that I was conservative, instinctively, inherently, I guess, DNA-driven conservative. Until really, I guess I got to college and political issues swirling around.
Where'd you grow up?
I grew up in Alabama.
And where'd you go to college?
Alabama, the University of Alabama. Roll Tide.
I knew that would make some people happy.
Both college and law school. And so I didn't, that's when I, started becoming alive to political issues and basically hearing the things that I was hearing from my professors and some of my classmates. And this is crazy. This is crazy talk.
Do you remember what the issues were that people were talking about that made you feel that way at the time?
No, not any particular specific ones, Mark, that come to mind. Just every damn thing that was
same stuff they're talking about now, only maybe a little crazier.
Yeah, really, that's true. But the environment was different then. We, at least, for example, seemed to be able to agree on things like pronouns.
Very difficult now. I apologize, I didn't ask you your preferred pronouns, Chuck. I'm really blessed. I have a daughter at Hillsdale College and a son who just started Scalia Law, so they're not worried about pronouns either.
Thank goodness. But You're not running any risks here, Mark, I promise you, with me.
So, throughout your career, I talked a little bit about your career. You ultimately ended up being known as one of the top Second Amendment attorneys in the country. First, how did you end up specializing in constitutional law, and then how did you end up specifically in this area of the Second Amendment?
Okay, well, I was blessed, uncommonly blessed, to have clerked for Justice William Rehnquist. Now, that was a pivotal, kind of everything changed for me after that, to say the least. And for a graduate of the University of Alabama Law School to have clerked there it hadn't happened before or since. But so just a lightning bolt struck me, and in fact, to the extent that after I was there and I'd served him along with co-clerks, Rhodes Scholars and everything else, and I started looking through the resumes of people who wanted to clerk the next year. I thought, oh my God, how did I get here? How did I get here? And so I marvel at it. But learning so much at his side, working as a law clerk to Rehnquist, it really opened my eyes to a lot of things. First, loving. As I say, being conservative was in my DNA. So, and he was the only conservative at the court in OT 78, October term 1978. The only conservative there. So my dream had come true in every possible respect. But I learned so much more about the Constitution. I learned about federalism. He was a federalism. He was so much. But I also learned firsthand and became very disillusioned firsthand as a young 20-something recent law graduate that the Supreme Court has the power to be a government of men, and it will exercise that power. It will exercise it. There was a case called Weber, and it was an affirmative action case. And they upheld discrimination in that case, a statutory case, not constitutional, but in that case they upheld discrimination on the basis of race, notwithstanding the clearest possible language and the clearest possible legislative history of that language that could possibly be written. As disclosed in a lengthy dissent authored by Justice Rehnquist. I commend it to you. So I left knowing that 5 justices basically agreed on what they knew to be a lie. They knew it. And that's colored everything. It's colored my life really ever since. I returned to the South, to Atlanta. Didn't realize how much I loved Washington. I know that's crazy to say, but loved the things that are only in Washington to the degree that they are: government, public policy, constitutional issues. And so I got involved in the Reagan campaign and sent my resume into the Department of Justice when lightning struck, and he was elected. And one day in my office, I had a call message from some guy named Ken Starr. And I went up and was privileged to then start working at the Department of Justice. Now, how did I get focused on the Second Amendment?
Yeah.
Well, after I left the government, after both terms, I was like every other lawyer coming out of government. I was just staring at my phone. Did corporate America not hear about me yet? Did they not get the announcement? The phone, is this thing going to start ringing? Anyway, the first time it rang, the voice at the other end was Wayne LaPierre's. Wayne LaPierre. And from that moment on, I represented the NRA in just a whole lot of things. Not little things, but the big things. And it was 30 years of being comrades in arms. And the Second Amendment, of course, I had always believed in the Second Amendment, but even more than that, I believe in law. I believe in the law.
So we're running a little short on time. If you guys would indulge me, we're going to run a couple of minutes over. Is that okay, guys? All right. There are a couple of questions I want to ask you, two specifically. One is, you and I met at a meeting at the Jefferson Hotel, and that goes back 5 years or so. Could you describe that meeting from your perspective and what happened there?
Yes. Yes, the Jefferson Hotel, we were called together. I believe it was Mike Ferris who organized it.
I think it was actually the Federalist Society. Mike had asked for help, and I think it was Eugene and those guys, Jonathan Bunch over there.
All right. Well, I associated.
You might have gotten the call directly from Mike. Yeah.
In any event, they gathered together, like a dozen or so, a dozen or 15 like-minded conservative lawyers, believers in the law. And I was privileged to be there and honored to be asked to come, and it was for the explicit purpose to talk about the Article 5 amendment process and the Convention of States method. Something that Mike Ferris knew, as did the FedSoc people, because I'd been on this for a long time, had FedSoc conventions, that I had long advocated what I have here today, constitutional amendment to address the Supreme Court's life tenure. Now, I testified in Congress in favor of the balanced budget amendment earlier in my career. So amending the Constitution was not something that, I was scared of. And at that meeting were people like Robbie George, you,
Levin.
I'm sorry?
Mark Levin.
Mark Levin, of course, Mark. Great one. And truly is. He was then too. I gotta remember, he was chief of staff to Ed Meese. And he'd say, okay, what are we going to talk about here? Okay, Chuck, what do you think? Go.
Very good.
But Nelson Lund, there were some Ambassador Boyden Gray. There was a number of people. Leonard Leo.
Yep.
And anyway, we came together to discuss somehow bringing life to the Convention of States method, and to oppose and to form a organization to answer the arguments being advanced by conservatives who opposed the ideas of the Convention of the States. And so I have to say, Mark, I've been to a lot of those lunches, and usually you get a free meal out of it, and that's about it. Look at this. Look at this. This is simply unbelievable. I have never, ever been at one of those lunches that ultimately took root the way this has, because of people like Mark and Patty, Mike Ferris. It's simply Senator Coburn, of course. So I would have bet probably my last dollar that something like this wouldn't have happened. So this is a miracle in progress right here. No question about it. It's unbelievable.
So, I go into this meeting, and I got to give you my perspective. Literally, so these are legal giants in this meeting. I've never met Chuck before. I knew Mark Levin a little bit. Certainly had never met Attorney General Meese. Guys like John Eastman and Nelson Lund and C. Boyden Gray, Rob Nadel, like these are giants, right?
Nadelson, yeah, he's the intellectual. Yeah.
Yep, and I walk into this meeting literally feeling like a little leaguer at the Major League MVP lunch. And it's just extraordinary. And so Leonard, by the way, had warned me about these lunches. You've never attended one of these, Mark, but here's what happens. He said, you got 10, 12 lawyers, lots of big thinkers, maybe some big egos in the room. There'll be 12 lawyers, 15 opinions. There'll be a lot of argument. Nobody will agree on anything. Don't be distressed if people are arguing about this. And I can handle it. It's fine. And we go in there, and Rob makes his presentation. I think Mike Ferris said something. I said something. And then we wait for the fireworks. Right? This is what Leonard tells me is going to happen. Everybody's going to argue about it, right? And what happens is there's kind of silence afterwards, and I don't remember who it was because it's all a blur to me, but somebody said, okay, what do we need to do to make this happen? Yeah, it was a miracle. And I remember we took a lunch break. I remember walking out and going to the restroom with Leonard, and I said, what in the hell just happened in there? And Leonard said, I don't know. And so that was kind of the start, and that's so what we have on our legal advisory board with guys like Chuck on there and Mark and all these other people on the legal advisory board, something nobody else has. For me, what I can say is when people say, well, legally you blah, 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 I just go, I don't know, look at our legal advisory board, right? What do I know? But all these guys know. So you guys have that. You have Chuck who has your back. You have all these other lawyers who have your back. You have the firepower of the legal advisory board because of that meeting that day, because of that conclave that day that led to all of this. It's really incredible. One last question, we're running behind, but this is obviously super current. I got your permission to ask this question. Obviously there's a lot of stuff going on at the NRA right now, and I'm really saddened by it. It's really frustrating to see. I don't think it's a good time for the country, for the NRA to be having trouble. They've been such an incredible force for good on so many fronts. You've been inside. Can you give us your perspective on what's going on? I know there's stuff you can't say, but whatever you can.
Yeah, there really isn't much I can say. I'm a lawyer. I'm a lawyer to the NRA, or at least I have been until
yesterday.
So talk about timing.
I got a very interesting email from Chuck yesterday.
And as a lawyer, I have a duty, unbreakable duty of maintaining confidences of the things that I know, even for former clients. But if you have, Wayne LaPierre, people like Wayne LaPierre, again, I love Wayne LaPierre. Man, I've been in battles with for 30 years. But people like Wayne and Oliver North, who I also go back with even farther, with a rockier beginning. But for those of you who remember Iran-Contra, I was the witness in that congressional hearing before him. I didn't have a stack of telegrams on the table that high, though. But figures like that in our movement, in the Second Amendment movement, Chris Cox, leaving, and now others, me. The NRA is in turmoil. It's in turmoil. It's in a rough patch. I am confident that it's going to come out of it and get its feet back under it and be everything in due time that it has been and mean everything that it has meant. But it is truly an indispensable, in my opinion, indispensable organization.
So I'm going to say one last thing, and we'll close with that, which is, and this is really important what Chuck's talking about here, and it concerns me a lot in the conservative movement generally. When we have giants in the movement that are having difficulties among each other, it's not good for any of us, right? I'm very personally worried about what's going on with the NRA because of its effect on the country. I think it's been an organization without parallel in its field. We have the situation, we have the improved situation regarding the Second Amendment largely because of the NRA, because of the muscle of the NRA, the political acumen of the NRA, the skill set, their willingness to go into battle. So when organizations like that struggle, it's not good for any of us. And we see this, and I think this is really important in the conservative movement. We see this, you'll see rival organizations, they'll point fingers, they'll clap and smile about it. We should never participate in that, right? Ever. In the field of the Second Amendment or any other field, right? We wish our competitors who share our values, when there are competitors who share our values, we wish them the best, and we always pray for them. And I would close this session, Chuck, just by asking all of you to keep the NRA and all those icons in your prayers as they work their way through this difficult stuff. Thanks, Chuck. God bless you for being here.
Thank you.
Go to conventionestates.com, press the button, sign the petition. More importantly, get 10 of your friends to do the same. When you sign the petition, then that sends a letter to your state legislator. You go on the list in their district as a supporter. We deliver those lists to the state legislators. It means something to them.